Hello, class. This video is a recap of the content of week 3 on the courts or the judiciary, as well as a look ahead to week 4, which is our midterm week. We also, in week 4, at the beginning of the week, cover the presidency, chapter 12, and the bureaucracy, chapter 13, because they kind of go together. So please ensure you read chapter 14 and then 12 and 13 if you have not already. You should have seen these slides in your content for week 3, but if you haven't yet, I'm going to walk through some of the content in them with you in this video to explain a little bit more. But I'm hoping that when you look at the slides and you look at your textbook together, that's very helpful for learning some of the important content. Pardon me. So chapter 14 about the judiciary or the courts includes a lot of important key concepts. Many of these are those bold words that you can find in your textbook in the chapter. So for example, when I go to a page with a bold word, I can find its definition. Let me see if I can find a good example. Let's go back to the beginning of the chapter. There we go, criminal cases. So when I click on that, I can see the definition of that, and I want to understand what all these terms mean and how our book defines them as I go through. There are a lot of important terms. Not all of these will be bold words in the chapter, but they're all contained within the chapter. There are a few things we need to know about our U.S. courts and court systems, and this is one of them. The difference between civil and criminal courts and civil and criminal laws and legal cases. So what makes a case criminal versus civil? If it's criminal, there is a violation of law involved, and generally one party to that criminal case will be the government, the state, the local authority, etc. One party to the criminal case is usually the government. Civil cases are disputes between people or organizations, everything from divorce to contract disputes to business law related disputes between two parties doing business together. You can sue someone in a civil court for defamation or libel. You can even sue someone in a civil case for a criminal action that they did, but you're looking at that point not to punish them just within the bounds of the law, but it has more to do with other laws about the two parties and their interactions. Both these types of cases have different thresholds for proof. If you want to find someone guilty of a criminal offense, in theory, it must be beyond a reasonable doubt. We've seen that in countless movies and shows, if not expressed in real life. Whereas in a civil case, it just has to be the preponderance or the majority of the evidence seems to point to the fact that that one party did wrong to the other. We talked about some examples, and then an outcome prior to ruling, that's like when the two attorneys, the two parties get together and make a deal, usually because one of them doesn't think they're going to get the ruling from the court that they'd like. So in a civil case, it would be a settlement, like we sign a divorce agreement where you get this and they get that. But in a criminal case, it would be a plea bargain, like this defendant agrees to this reduced sentence because the state doesn't think they can win, or etc. So, pardon me, both of these kinds of cases, civil and criminal, can take place in a federal or national court, which is actually a vast system, or those cases can take place in a state court or a local court, etc. The vast majority of cases will end up in a state or local court. For every 63 in a state court, there's one in a national court. State court systems may be similar from one state to another, but the nuances are different in every state. The federal court system um, extends across the country and has three parts within it as well, that we need to learn about. So you see how in the small triangle on the left, that's part federal courts and part state courts. And then if we were to blow up that small triangle, that's just federal courts. On the right, that's the rest of the federal system that's contained in that federal court system overall. So you have at the bottom, if you have a federal issue, and we'll talk about how you get into federal court in a minute here, you would start at a district or trial court. Your case might go up to a U.S. Court of Appeals if you go up to that level. And then finally, if it meets certain criteria that we'll talk about, it will go up to the Supreme Court of the U.S. These federal courts or national courts are also called circuit courts. So here are the federal circuits or the district courts. So there will be one court district covering several states. It's more by population than geography. So there can be a few federal courts or several federal courts across each of these circuits or districts. And you can see there are 11 of them. These U.S. district courts, what kind of cases get to them? Why is it in a federal court instead of a state or local court? If it's a federal criminal case, like, for example, the FBI caught someone, or some other national law says the crime was a federal crime, or maybe it extended across a bunch of state boundaries, etc. So those cases can start in a federal U.S. district court. You also can have civil cases in those district courts, but usually it has to do with a national law, like a law passed by Congress, having been violated. The government can also bring a civil case against groups, or groups can bring a civil case against the United States or a certain department of the government, or etc. Civil cases, yes. And then if there are like two really big businesses, for example, in a controversy for like more than 75K, but for example, if it were for millions of dollars, that would start in a U.S. district court, a federal court. So going back quickly, so these district courts are the bottom of this system, this pyramid of federal courts. Okay. And in district courts or circuit courts, there is only one judge per case, but it might be presided over by a magistrate judge as an assistant. Then, let's say your case got resolved incorrectly or didn't fully get resolved in the circuit court. It might make it up to the next level of the triangle, which is the courts of appeals, U.S. appeals courts, federal appeals courts. And these also, there's one appeals court for each circuit. So they're not going to hear every single case, but there are scenarios in which they will. And essentially, it's when there is a question about a specific legal aspect of the case that was already heard in the first federal court. In that case, like, for example, if something wasn't handled correctly about someone being read their Miranda rights, when the federal case was heard and the judge there overlooked that issue, but the attorney for the defendant says, this is a big issue, they didn't handle it correctly, so then the appeals court will look at that maybe. Or they could also look at a civil case again. And they're not going to retry the whole case. And they're a panel of 3 judges, by the way, but they're going to look at that case and say, yes, there is a big issue with how that judge handled the way that evidence came in for this defendant regarding his or her Miranda rights. and maybe there needs to be a new trial in that case. What they do is they look at that specific issue and they always write and publish a judgment. They might not hear, like, they might not have any live proceedings, but they might hear the attorney's oral arguments on each side. But again, they're not going to do a whole trial again. They're not going to bring the witnesses, etc. So they're there to correct errors. They're there to interpret the law. And like the Supreme Court, which we'll talk about in a minute, when the appeals court publishes a judgment, it becomes a precedent. Precedent, meaning something that comes before or happens before. So each case that is like that after that can refer back to how the first one was decided. So, or another way of saying that is the appeals court may make a ruling that applies to all similar cases after that and is a guideline for that. Stare decisis is Latin for let the decision stand, and that's just another way of explaining precedent. This is a side note, but judges and courts will not always, follow precedent if they think there's a really good reason to interpret the law in a new and different way, or if they think they're looking at a different situation. That said, the most typical approach is to stare decisis, or let it be a precedent, let the decision stand. Okay. Historically, so we talked about separation of powers, and one of these separations of powers is that while the judicial branch does all the things that we talk about in the context of interpreting the law, the legislative branch, they're the ones who decide what federal court system we need, how many federal courts, what are the circuits. So in other words, Congress, they can decide, how the court system is going to work, and they oversee it. This is in Article 3 of the Constitution, but Article 3 did not give them complete free rein. The Constitution provides that there must be a Supreme Court, a highest court in the land. Again, the founders could not have anticipated that our US population or even geographic size would be as big as it is now, but that's why the court system has expanded over time to try to account for that. But they used to have judges for these federal courts covering a wide area, and they would, ride around in their coaches and carriages and whatnot. And that's why they called it riding the circuit back then. So you had to wait till the judge came to town in order to have your federal trial. Okay, let's talk about the Supreme Court. How does a case get to the Supreme Court? And this diagram is in your textbook, and you want to understand it. You wouldn't have to redraw it, but you want to understand each aspect of how a case would get to the Supreme Court. So, first of all, either from the very first triangle we looked at, federal courts and state courts, either system can feed a case into the Supreme Court. That is because the only cases that should be considered for the Supreme Court to look at are if it questions a federal law, a federal treaty, or the Constitution. That said, that could happen in a state court as well. If you're already in the federal court system, you would probably have to go up through first the district or circuit court, then the appeals court to get to the Supreme Court. And even then, your case might not be heard by the Supreme Court because there are just too many. As you see in this chart, in 99% of the cases, of the requests, they must be denied because they're only one court and they just can't hear any more cases than that per year than they're already hearing, more or less. So, for example, there'd be over 4,000 requests and they'll hear 1% of them, or they'll look at 1% of them. Court We'll discuss that list in conference, and that's with the 9 justices who sit on the Supreme Court. If 4 of those justices think that one case is worth reviewing, then they will do it. That's the rule of 4. So it will go on the docket. And the docket is like the Supreme Court schedule for this is the list of cases we're going to hear this year. So they do it annually. Then there will be briefs on the case, just information that the justices can read. Some of the cases will get an oral argument, which is, when you think about them actually being in court. Then after the oral argument phase, there will be a conference again. So then the justices can discuss. They usually don't discuss a lot. They've come already knowing what their colleague is going to say or what they want to say. And then it will end in an opinion. And so we're going to talk about the types of opinions the Supreme Court justices do and each outcome that a case can have as well. But just food for thought at the bottom, a question your book raises is whether you think the Supreme Court is hearing enough cases or whether you think they're hearing the right cases. I'll also add here that typically the cases that they're reviewing have to do with the Bill of Rights. If it's a constitutional issue, there can be many other reasons why the Supreme Court will hear or review a case, but that is one of the big categories of cases that they tend to hear. Okay. Pardon me. Here are our current justices, and below at the bottom there, it just shows them in the order of when they were added. We'll talk about the justices a little bit more in a minute, but there's usually 9 of them. Folks across government and in the public have discussed, and over the years, presidents and others have looked at expanding the size of the court, adding more justices, and there are a bunch of reasons for this. But for now, let's talk about what are all the outcomes after your case goes through the Supreme Court, what can happen? So the judgment is like the decision, not to be confused with the opinion. The opinion explains the decision, and usually, so then the Chief Justice will decide who's going to write this explanation of the decision. And all justices can review it and ask for edits here and there, but say, if, say, the Chief Justice asked Justice Neil Gorsuch to write the opinion, well, everybody else doesn't have to agree, but they can all ask for edits before it's finalized if they think it's worthwhile, because this is going on the historical record. This is a precedent, meaning like all the lower courts need to follow this decision from now on. The argument that goes in the opinion. It's the heart of the opinion, and it just tells you the logic, like what is the legal issue? What is this case about in our view? Because some cases can be complicated and they may seem to have more than one legal issue, but in that argument, the writer is trying to say, this is the crux of the legal issue. This is what matters. So, okay, let's say if Justice Gorsuch wrote the opinion and maybe Justice Amy Coney Barrett agrees with him, but she doesn't agree with his reasoning, his explanation. She wants to write a concurrence. And so she can write another opinion, which is called a concurrence. Like, yes, I agreed with the court's ruling in this matter. I voted for the decision that the judgment that we got. However, I actually think the crux of the legal matter is this, or I think it's most important to bring out this aspect of the case. And then the dissent. So then maybe Justice Sotomayor or Justice Jackson, they do not agree with this decision, this judgment, So they can write, it's basically another opinion, but explains um, what they think the judgment should have been and why they think this is important as the Supreme Court, why they think it should have gone a different way, and what the legal issue that is and the outcome should be in their eyes. A lot of what the justices do is constitutional interpretation. And if you think about, bear with me here, a religion, right? If it's one of the ones that focuses on one main book, like the Bible or the Torah or the Quran, right? Within those larger religious branches, you can find people who want to read that main book a lot of different ways, right? And it's similar with the Constitution, even among legal experts. You know, there have been justices that prefer a strict textual interpretation. They want to just follow exactly what it says. What did the words mean to the writers? What it says is what it means. Of course, that can get complicated because there are situations that, no one in around 1800 had any clue were going to occur. That said, some people think that's a valid way to interpret it. You can look at the historical context to interpret the Constitution or an amendment. Again, a little bit of a slippery slope because then its protections don't really apply to anyone but white property owning men. Structural interpretation, like, okay, so we have in the Constitution info about how the court system should relate to the president and vice versa. So we should stick with the spirit of what is laid out there. Doctrinal interpretation. Well, I can use the text of the Constitution, yes, but I need to look at every other case that's ever had to do with that part of the Constitution. And then I really know what I should do. Prudential, and this is in real life, prudential interpretation happens a lot. They look at America or the part of America affected by the ruling, and they're like, oh, I'm sorry if you could hear a background noise. And they're like, okay, I care about what's going to happen, the good things that this interpretation, this decision could do, or the bad things it could prevent, or the bad things it could cause, etc. So they're actually looking at, what's going to happen in their society based on their interpretation of a law and of the Constitution. Traditional is a little bit similar to doctrinal, but it also depends on this idea that there is an American tradition. So they can look at, how was this law implemented in real life? Again, there could be good things about that, but there could be tricky parts as we adapt and time goes on. And as America is clearly not just only one thing, it's many things. So yeah. And finally, moral reasoning, moral interpretation. That comes up a lot in the Supreme Court as well. That said, moral often goes with prudential, meaning, for example, you looked at Brown versus Board of Education when they decided to make that ruling that said there could not be segregation in schools anymore. They did just think it was the right thing to do, but they also looked and thought America was ready. And we'll talk more in the Civil Rights Unit and Civil Liberties Unit about, what it took to actually get that implemented across the country. But so a lot of these approaches kind of go together. So please watch this video if you haven't already. This is also about civil liberties. And it's a Supreme Court case about flag burning that made it to the court and how they interpreted and approached the decision. And this is that website I was talking to you about. This oye.org is a great resource on the Supreme Court. And if you walk through this kind of experiential immersion into the Brown case, you can kind of see some of the things we're talking about at work. And that's it for the slides. I hope this was helpful. Thanks.